Good morning, everybody. I'm your host, the Supreme Litigant, and I am back again with another video. This will basically be part two of a bail bond as a contract. So I found a very interesting case that I want to go over. You can find this case citation in volume 775, Northwestern Second Edition. It'll be on page 907. This is Minnesota, it looks like. Yeah, this is state of Minnesota. Okay. So I'm going to scroll down. Y'all can read the whole entire case if y'all want. I'm going to focus on one issue. Okay. And that is right here. These are the issues that are presented to the court. There are three issues, but I'm going to focus on this one. There's a bail bond, a contract. And we're going to go to analysis one. And we're going to start right there. Before I begin with this, if you haven't already, please go ahead and subscribe to my channel and hit that like button. Also, if you're having issues with understanding anything, all you have to do is ask questions, comments. That's really helpful. And I'll be going live tonight, either at 5 p.m. Central Standard Time or 6 p.m. Central Standard Time. I don't know yet. I'll let y'all know soon, but I don't know yet. So we'll start here. The threshold question for our review is whether a bail bond is a contract governed by the traditional principles of contract law. The district court decided the question in the affirmative, and we agree, meaning the district court said yes, and they agree. The formation of a contract requires communication of a specific and definite offer, acceptance, and consideration. This is letting y'all know that the UCC does apply, just to let y'all know. The Uniform Commercial Code, it does apply. The UCC governs commercial activity. I'm going to read this one more time. The formation of a contract requires communication of a specific and definite offer, acceptance, and communication. And then there's the cases to support their contention. Suretyships or surety contracts are characterized by the relationship among three parties: the surety, who is bound on the obligation from which the principal, by the discharge of a duty, should relieve him. 2. The principal, who, in the solution of the rights and duties of the parties, should bear the ultimate burden unless excused for some reason personal to himself. And 3. The creditor, to whom the surety is bound and to whom the principal is under an obligation or other duty. And then there's cases right there to support it. Discussing the nature of bonds as surety contracts. Applying these principles, the district court concluded that a bail bond is a contract because there is an exchange of promises and consideration among the surety, the bonding company, the principal, which is the defendant, and the creditor, the court. The district court described the nature of the bond contract succinctly. In effect, the bond contract is a three-cornered agreement. The state grants to the bonding company the right to provide surety for appearance of the defendants and quasi-police powers to secure their custody in the event of a non-appearance and the defendant released from custody upon posting of bond. The defendant agrees to appear before the court and to pay the bonding company a fee to issue an appearance bond. The surety bonding company receives a premium and promises to the court that the defendant will appear, or that the face amount of the bond will be paid. This is business. Yeah, this is business. The district court's characterization is supported by precedents. While it does not appear that any Minnesota cases have expressly held that a bail bond is a contract subject to traditional principles of contract law, at least one case has described a bail bond as a contract between a surety and a principal. And there's right there. There's the case right there, which described the bail relationship in terms of a surety principal, which is of a surety principal, the defendant, being released into the custody of his sureties, the bonding agent. Additionally, the Eighth Circuit of the Court of Appeals, that's a federal court, by the way, has defined a bail bond as a three-party contract which involves state, accused, and surety, and under which surety agrees. State that accused will appear at subsequent proceedings. Scroll down a little bit more. A bail bond is a contract between the government on the one side and the principal and surety on the other. Like other contracts, it must be construed according to its expressed terms. Given this precedent and the fact that a bail bond so clearly fits the definition of a surety contract, we uphold the district court's conclusion that a bail bond constitutes a surety contract. So, because it's a contract, they have to apply general principles of contract law because it's a contract. I'm just letting y'all know that it is a contract. These people are doing business with you. That's what they're doing, man. They're doing business, man. That's what they're doing. Let me go here and see what Alabama says, when it comes to contracts, and see if Alabama has the same principles. The requisite elements of a contract include an offer, excuse me, an offer and an acceptance, consideration, and mutual assent of the terms essential to the formation of the contract. See that? Same shit. Damn near the same shit, man. I'm just letting y'all know, man. They doing business with you, man. They doing business with you. So hopefully that'll help y'all understand what's going on. A bail bond is a contract. Don't let these people trick you and fool you and call you names and all. Forget all that. It is a contract. That'll be the end of this video. The Supreme Litigant is out. Peace.